Hey, I just want to have a little chat about a case from the New South Wales Supreme Court, 2008 case of Fitness First Australia Pty Ltd and Chong. So this case relates to the well-known brand of fitness gyms. They operate, Fitness First operates a chain of health and fitness clubs all around Australia. Mrs. Chong, Sue Chong, became a member of a club in April 2007. Both parties signed a written contract on that date. The written contract stated that Mrs. Chong agreed to a 12-month membership, with the membership dues being payable every fortnight. It also stated that if she terminated the contract before the 12 months had elapsed, she'd be liable for a $200 cancellation fee, particularly if she did this within the first 2 months of the membership. Mrs. Chong didn't read the terms of that agreement. Imagine that, joining a health club and not reading the terms. I can't believe it. I probably do it every January, but I can't believe it's possible. Anyway, she was not aware of the cancellation fee, and when she cancelled in the first 2 months, she refused to pay the fee, and Fitness First sought to claim that amount in contract. So Mrs. Chong had a couple of arguments. Firstly, she argued that she didn't know about the fee, so she didn't really agree to it. Secondly, she said that she was not ad idem with Fitness First. They hadn't actually had a meeting of the minds in relation to the subject matter of the agreement. And lastly, she said it just really wasn't reasonable to expect ordinary people to read complex terms and conditions, particularly when they're provided in fine print. On the other hand, Fitness First argued what Mrs. Chong did or did not know is a subjective test, and accordingly it is irrelevant. They cited Toll and Alpha Farm, which is a case we'll come to later, as the preeminent proposition that a signed contract is in fact binding. They argued that a reasonable person wouldn't regard the signing of the contract a reasonable person would regard the signing of a contract as an outward manifestation of a person's intention to be bound by the terms. And the fact that she didn't read those terms was not their problem, effectively. Ultimately, the Supreme Court found in favour of Fitness First. Ultimately, the Supreme Court in New South Wales agreed with the tribunal's finding that the general rule applied to this case. So what is the general rule? The general rule, which we will discuss later again when we talk about the case of Toll and Alpha Farm, or the rule in Lestrange and Graucob. So the general rule is that a person who signs a document which that person knows will contain contractual terms and expects to create a legal relationship will be bound by those terms. And it's actually immaterial that the person hasn't read the document itself. So they found that Mrs. Chong was bound by the conditions in the contract. The validity of the contract did not depend on whether or not she had the requisitive consensus ad idem, in the sense that each party fully knew and understood the terms of the agreement. Rather, consensus was found by the fact that the terms had been read. It was not Fitness First's problem, effectively, that she had not read the agreement.